Okay, Elias, what made you go into criminal law?
Oh, I never got terribly inspired by money. When I was going to law school, it was interesting. I found some people in my class, there were a few who always wanted to be lawyers, and most were intelligent people who never seemed to find a niche. And I think I was one of those.
But the criminal law is your niche?
Criminal law, yes. I like it for two reasons. One, because it's got a high stakes interest component where people are basically putting their liberty on the line. And two, it's like a puzzle. If you can turn the facts and turn the law and twist them and weave them together in certain ways, you can come up with arguments about why someone should be acquitted or why there was a mistake. And it's intellectually quite interesting.
Now, you seem to have gravitated to appellate work in the last while. What makes that more compelling?
For me, it's more compelling because of, I think, two things. One, I like working quietly alone, which is not compatible with trial work. And two, I like reading and researching. So there's a lot of time for quiet reflection, for analyzing an issue, thinking about things, turning them over in my mind, discussions with other lawyers to put arguments together, as opposed to trial work where you have to think fast on your feet and it's not very forgiving, because if you don't come up with the right answer right away, your time is passed. Appellate work, I much prefer. It's good for an introvert.
Now, you mentioned reading and research. A lot of people look at criminal law through the lens of their television, where it's glamorous and things are done in 5 minutes, and it's Hollywood. But like you said, what you do is a lot of reading and a lot of research. It's certainly not glamorous.
No, and when I used to watch Law and Order, the only thing I'd find, well, the thing I found most unrealistic would be well-dressed people with perfectly done hair would come in the morning and have a brief and it's ready and it's this thick. Whereas the truth is, if you count the hours that you put into it, it's hard to justify how long an argument took to put together, how much reading you have to do to put it together. But it can dovetail in a way that it just makes it beautiful, like a spider web in the mind, where it all comes together. And I find it really, really rewarding.
It's going to be frustrating, though, when people don't appreciate the amount of work you have to put in for what amounts to a 45-minute argument at best.
Well, it's funny because I've had people say, how can it take so long? You just have to file the paperwork. And it's not just paperwork, but of course, any time that you see somebody do something well, when they make it slow down so that it looks easy and effortless and simple, that takes a lot of work to refine. If it's a big complex argument that loses the audience in the process, you haven't done your job, at least not in criminal law, not in appeals. But to bring it down to 45 minutes, make it persuasive and compelling and actually get the right result, that is the job.
Appeal work must, just by its nature, be more difficult because you're dealing with the judges who are deemed to be the bright lights of the bench, and the Crown prosecutors are similarly people who have been deemed to be very knowledgeable in the law. Is that a source of pride? Is that a source of consternation that you're going up against the toughest of the tough?
Well, I think that's a good theory. I don't know if it always works. In some cases they are, in some cases they aren't. But I think in this job, it's not amassing a certain amount of knowledge in order to get your point across, but rather finding how to make what's out there persuasive. And if you can read your audience and know which fights you can win, that's the secret of succeeding in appeals.
Now, when you look back on your large volume of work, are there any particular cases that just always come to mind when you're thinking about your past career?
There are, And sometimes the ones that were the most fun was the ones where we were able to develop a theme. And I was very fortunate with Mr. Lutz over time. Years ago, he asked me to do an appeal for a guy who had served his sentence and discovered the immigration law was changed retroactively. So he would be deported, whereas at the time that he was sentenced, he wouldn't be. And over the next several years, that theme kept coming up over and over again, the nexus between immigration law and criminal law. And it finally culminated actually in a Supreme Court appeal, which became an important sentencing case. But having acted over and over and over again with the same issue, each time in front of different judges, each time with different case law as a background, it's really nice to see the whole thing come to fruition and become the law of the land, having had some hand in developing it.
I take it there's a reward here, though, basically representing people who are marginalized members of society, people who have had a very bad time in their life, and you're able to give them the kind of help that they've probably never had before.
Actually, some of those are the most rewarding, where a number of different times I've had clients who are bipolar, schizophrenic, some form of mental illness, which doesn't mean that they're not criminally responsible for their actions. And the law sometimes treats that in two ways. Sometimes it's mitigating because they're not morally to blame in the same way that others are, and sometimes it makes them more dangerous and then the law treats them more harshly. But helping out people who have mental illnesses, brain damage, and other deficits, I think it's a way of paying back to society. It's actually very rewarding. Career-wise, those cases are most rewarding.
How do you deal with someone who says, "Oh, you're a criminal lawyer. You're getting the bad people back out on the streets. How can you live with yourself? How can you sleep at night?"
Easily. If there weren't for criminal lawyers, the system wouldn't be honest. I don't know that it's always honest. And there are people who are wrongfully convicted, and I think it's far more common than most people appreciate. Anyone who thinks criminal lawyers are not doing a good service are usually people who've never been in trouble. And even for those in trouble, they need to be treated honestly, decently, and fairly. And if no one stands up for them, it's too easy for them to slide by the wayside.
How do you deal with someone who comes into your office and you know that they don't have much of a hope?
Well, usually I just tell them the truth. I mean, sometimes there's a merit in running something anyway. Sometimes people need to run an argument so they feel they've exhausted all of their options. Generally, if they haven't got much of a hope, I just tell them that.
Now, people also probably don't appreciate the fact that the law is constantly evolving. I mean, how do you stay ahead of the game?
Well, that's what keeps it interesting. I mean, when you first start, when people go into law, a lot of junior lawyers think it's going to be black and white, and there's a yes or no answer to things, and things will stay the same. But it's constantly shifting, constantly evolving. I mean, probably the best example these days is how technology changes searches. What can they look into your phone? Can they examine your computer? Can they have you under a camera in a public hallway? It's absolutely fascinating how the law is constantly changing, and it keeps the arguments interesting. Yes, a lot of people think the law is black and white, but it never is. And your audience, when you're arguing something, is always the judge or the panel of judges in front of you. And if you can persuade them to look at it your way, the law might change a little bit more that day.
Earlier I was talking to Jim about disclosure, and I mentioned that the adjective I most commonly hear from lawyers when they describe it is voluminous. By the time cases get to the appellate level, not only are you dealing with all that disclosure that has to be reviewed, but transcripts of the trial and transcripts of judicial decisions. How do you manage to get through all that and find the focal point for your argument?
Well, When a person is going to trial, the question for the judge is, I suppose, what happened? The question for the defense lawyer is not what happened, but can they prove it, and can we undermine what they think is their proof? When you get to the appeal stage, what happened is what the judge said happened, and usually there are very few arguments that can set it aside. But the focus is far narrower. Where did the judge go wrong? The appeal is from the verdict and the judge's decision, so people keep coming back and saying, yeah, but that's not what happened. Yeah, but that's not what happened. Yeah, but that's not what an appeal is about. It's about seeing whether or not we can get this verdict set aside because the trial wasn't fair or the judge made a mistake. So no matter how skimpy or how voluminous the disclosure is, sometimes very little of it's actually relevant to an appeal.
Do you see a lot of that in your work, that the trial just didn't seem fair?
I do from time to time, and sometimes trials are so long and so involved and the details are so voluminous that judges miss the forest for the trees. So sometimes it works to our advantage in appeals, sometimes it doesn't.
So often you have to go in and cut down the forest to get the court to focus on what really should have been the focal point?
Yes, usually in appeals it's weeding out all of the noise and all of the clutter to narrow down on what actually went wrong in a trial. And the rest of it, as long as what went wrong had a bearing on the verdict, you've got an appeal.
So what is your philosophy of criminal law?
At this stage of life, I have learned to appreciate the role of criminal law as a exercise in civil liberties, but from a very strange perspective. Because those on the front lines are the ones testing the waters. What can the police do? How far can they push us? How much can they search? How much of our privacy is going to be invaded? And the ones who put themselves on the line for that and protect the constitutional rights of you and me and law-abiding citizens are people in trouble with criminal law, are those being prosecuted. So in an odd way, they're involuntary civil libertarians. They're the ones risking their freedom, their citizenship, their livelihood, their families, everything they've got, so we can make arguments that protect the freedoms of the rest of us, whether they appreciate it or not.
And also, especially in criminal law, there's a lot of emotion. Parties are involved in all sorts of conflicts. How do you avoid getting too caught up in the emotion of the case?
Well, that's easy. When a lawyer is preparing for trial, you've got to be interviewing witnesses, preparing your client, figuring out what your theory of the case is, and in that way it's very hands-on with the people who are involved. Appeals are not. It's review of transcripts, it's review of case law, collecting the exhibits from the trial. So it's a very isolating experience as opposed to an interactive one.
But still you're looking at and reviewing material that can often evoke strong emotions, and you might have a client sitting next to you or close to you that has so much on the line. I mean...
That might be so, but if I try to be a social worker and a criminal lawyer, I'm not doing a service to either profession. So even though people have a lot on the line, it's up to them to find ways to deal with it emotionally so that I can do my job.